a very long day for you guys as well. So thank you again. Well, we're going to start by having you introduce yourself, say the race for which you're running, and then indicate why you decided to run for this particular race at this particular time. And since we are chivalrous, we'll begin with you, Kathleen.
Thank you. My name is Kathleen Delaney. I'm the District Court Judge in Department 25. I'm running for re-election this year. It was a 6-year term I was elected to in 2008, and I am running for re-election because I think this is one of the best jobs you can possibly have as an attorney, especially one who believes very strongly in public service.
Okay, Craig.
My name is Friedberg. I'm running for District Court Judge in Department 23. This job is important. Running for this department at this time to make a difference. I want to be able to bring integrity, fairness, equality, justice to this community. I have been an attorney for 28 years as a trial lawyer, 8 years as a part-time judge. I want to bring that experience, that knowledge, that level of the law to this department. I want to make sure that when people come to this department, they know they're going to get a fair shake. And also, I'm running because I want to give back to this community. I've been here for 24 years, and it's important to me. I met my wife here, raised my kids here, and I want to make sure that as a judge, that we use that position as role models and mentors to our youth. And there is lots of information on my website at friedbergforjudge.com that gives even more specifics as to what I want to do with this department.
Thank you. And Sean, before you go, let me say something I had said previously. I have, just as full disclosure, I have no pending cases to my knowledge. I have no pending cases in District Court 25. The last time I was in there, I was covering for a buddy about 4 or 5 months ago, and I think I had a sentencing in front of you last calendar year.
Yeah, it's been a while.
So unless it comes up for revocation literally in the next 2 weeks, I don't think I'll have there be any conflicts. Regarding Department 23, the same goes in that department, although I think it's been even longer since I've been in there.
Have you been working at all?
I've been focusing too much of my energy. I've been focusing on AAG. So there's a litigator. But I have nothing pending in Department 23 either. So I'll be. Unfortunately, I can't slough off the endorsement duties to someone else. So, Sean, I did cut you off, but I did want to put that on the record just so everybody was on the same page.
I don't think I was cut off because I hadn't started speaking yet, so I appreciate that disclosure. My name is Sean Connell. I'm running for District Court Department 25, which means that I am running against Judge Delaney. I've always wanted to be a judge. It's something that has been a goal of mine since before I even knew how to become a judge. I hadn't decided to go to law school, but growing up it was something that appealed to me. So I've started working towards that in my legal career over the last 14 years here in Las Vegas. With regard to why I chose Department 25, I think in order for the electoral process to work, there has to be more than one candidate running for a position. So it's nothing personal against my opponents. I do think that there are some changes and improvements that I can make to Department 25, but basically I want to make sure that people have a choice.
Okay. Well, Sean, we'll start with you for the next question and then go back down the line. You had mentioned things that you wanted to change, perhaps in this particular department, but as a court system overall, what do you see as the biggest inefficiency in the system? And assuming you're elected, how do you plan on addressing it?
Unfortunately, the biggest inefficiency is completely out of the judge's control because it's based on the number of cases that are filed, and there's not really anything we can do to limit or eliminate that. However, once we do have cases before us, if I'm elected, then we can do everything in our power to move them along. So some things would be to make sure that the calendar runs smoothly. I know that there are some judges that break the calendar up so it's not a 3-hour cattle call for motion calendar. You can have an hour-and-a-half segment or maybe 3 one-hour segments so that people aren't sitting around waiting as long. Also, when matters are pending before you, if you issue rulings timely and keep the cases moving along, people aren't sitting around in limbo trying to figure out what to do next.
Okay, Craig.
There are some things that definitely can be done in this department. One is to have staggered start times. There's no reason for someone to have to pay an attorney to sit on their butt for an hour and a half waiting for the case to be called. There is other things that as a judge that can be done. One is to make sure that you've read all the material before you take the bench that morning. so that when you're up there, the participants aren't trying to re-argue what's in the papers. When you read everything and you've done the research and you know the law, then you can focus that oral hearing for exactly what points you want to have expressed in a greater detail. And instead of having a half an hour hearing, you can do it in 5 or 10 minutes because you have a very laser focused idea of what you want done. And that helps everybody else to keep things moving. There's also making sure that, especially this is a Department 23 is 50-50 civil and criminal, is to be cognizant of the other courtrooms that possibly the prosecutors or the police witnesses that are there have to get to. Maybe just getting back either out to the street where they should be to help protect our community, or if they're there and it's their off time, to get them back home so they get their sleep so they're not on the street with less sleep than they should be, because we all want to have our police and emergency personnel out there with the right rest so that they're helping the community the best they can.
Kathleen?
I think what I see right now as being one of the biggest inefficiencies is just how many folks are not represented by counsel at all. It's even a bigger problem in family court, but I have a particular docket, which is a vast majority of the homeowners that appear there, it's the foreclosure mediation appeals, have no representation. This is not necessarily something we as judges can control, but we can certainly be a voice for. The Supreme Court has launched, along with the Legal Aid Center, the ONE program trying to encourage folks to take cases. I recently reached out to some folks that regularly appear on that docket to see if they would volunteer to take some pro bono cases, not anyone in particular, but just see if I could round up some cards to be able to hand out as people need them. But it's been very, very difficult because affordability for many folks for an attorney is very difficult. And when you have somebody who is not familiar with the system, we can do the best we can to help move the thing along. But we have a lot of cases that bounce back and forth on the docket because the folks aren't attorneys and they don't know how to do the procedure and how to make it work. So really the best efficiency I could see is if we could just get more of our attorneys to take more pro bono cases.
I was going to say something, but I think it's more just because it's late in the day about...
Are the pro bono cases mandatory for?
I was going to get into that.
It is reporting on pro bono is mandatory, meaning you need to indicate whether or not you have done it. You either need to contribute a portion of time or financially in some way for the Legal Aid Center and invaluable services that do provide it, but it is not yet a mandatory requirement. But I think as people are becoming more and more aware, I get it, especially as a new attorney. I've got some friends who are newly minted attorneys and they're just so busy in their firms wanting to try to impress their bosses and they're not necessarily giving credit for their pro bono work. So I think it's an infrastructure thing too, or I guess I should say a internal thing in these firms in terms of encouraging and accounting the hours put towards pro bono work for the young associates especially. And it's such a great way to learn, but I don't think as many firms encourage it as could.
I guess I heard there's over 10,000 lawyers running around.
Actually, there's less
and
than that.
if one that handles 2 cases a year, like the CE credits, it would help tremendously.
It would be amazing,
tremendously to
and
the
they're really,
community as well.
they're doing everything they can to get people interested, and the numbers are coming up, but there's still a wait list of 100 or so people sitting over at Legal Aid Center right now.
That is really important to try to get, especially the larger firms, to have those partners get involved and have them understand how important pro bono work is and how they can have their younger associates in there getting incredible experience that will just help them, at the firm also.
So it's not required
Right.
for licensing.
Correct.
That you do.
It's not
Do
required,
other-
but it's encouraged.
Do
Oh,
out of
it's
their
only-
You
good,
have to
good
report
heart.
on it, whether you've done any or how many
Yeah.
hours, et cetera, whether you make a financial contribution, but it's not mandatory.
It's not mandatory.
But if it's tax deductible,
Big time.
then it becomes a big thing,
Ooh, that's interesting.
right?
Lots of ways I
That's-
think we can encourage and
yeah.
improve.
Oh, yeah.
Kathleen, it's weird calling judges by the first name,
That's
but I'm
fine.
trying to do it just to be as fair as possible.
I prefer it.
You have a good amount of experience with our specialty courts. You were handling the mental health court and the drug court program. What areas of improvement do you see in those programs from your vantage point, or perhaps derivatively, what areas of need do you see out there where specialty courts don't exist that you might like to see some judiciary individuals focus upon?
Well, right now in the 8th Judicial District Court downtown, we have adult drug court, felony DUI court, mental health court, and there's the same judge handles, along with those three, the competency court docket. I had that assignment for a little over a year, and one of the areas where we absolutely need to improve, although I don't know what the judiciary can do about it, but we can certainly assist and give encouragement, is there is a veterans court component to the adult drug court, and there's maybe, last time I checked, 15, 20 people in it. But there are clearly more veterans in our criminal justice system pending cases than that. And there's not been an effective way that we've ever found to identify all those individuals. Now, the judges are trying to be better about making those inquiries, trying to encourage the defense bar to make those inquiries and get the folks to the treatment programs that really need them. So there's a lack of, the program is there, and Judge Bell's doing a fantastic job overseeing the program, but there's not enough people in them because we're not identifying the people who need them. The other thing I think where we could improve, or at least we could add, is there's just not nearly enough resources for mental health treatment and mental health court programs. Right now you have to have what's called an Access 1 diagnosis, or a certain diagnosis, in order to be able to be eligible for our mental health court program, and I really wish they had a second tier or one that was open and eligible to Access 2 diagnoses, because it would make it available to more individuals, because really a lot of the folks that are out there, these are minor offenses in the grand scheme of things, and they're offending because they're not getting their meds or mental health meds.
It's interesting you mentioned the Access 1 diagnosis. You also need to have a criminal history behind you of rather minor infractions.
Yeah, non-violent.
Leading up, non-violent.
Right.
So you might qualify under the diagnosis, but if this is your first rodeo,
Right.
they don't accept you
And
into the
these are the
mental
people
health
who
court.
need it immediately.
Exactly.
They need that treatment. They need to connect to the services, the housing. You know, there's enough there that we could put people in touch with it, but the people aren't eligible for it. And so I think if there was another tier of mental health court, that's the gap I see.
Craig, specialty court.
One of the things I was going to talk about was veteran. I mean, yes, the buildup of the veterans court system is great, but it needs more work, and there has to be. And I'm not sure how we're going to fund it, because it sounds like all the extra discretionary money that the court usually gives back is going to be going into the appellate court system. So that money is not there. Why that money wasn't used prior to this year to help establish a more robust specialty court system, is something that I guess is above my pay grade. But I certainly would want to see that. The other specialty court in terms of expansion, I believe it was last year, the Supreme Court did allow the 8th Judicial District Court system to look into having a consumer fraud specialty court, a deceptive trade practice court. And I was really surprised when I saw that too. And we both come from deceptive trade practice, consumer fraud backgrounds. That's primarily what I handle is consumer protection rights litigation, along with intellectual property litigation and business contract law. And I would love to see that become a specialty court, because there are nuances of consumer protection work and consumer right and consumer fraud types of cases that a lot of judges just don't get because they're not used to them. One of them is that consumer right attorneys on the plaintiff side, they don't get paid by their own clients. They get paid by the defendants. There's fee shifting provisions that go into those type of cases. And it's not, I think a lot of judges look at those as if it was a PI case, and that you're trying to ask for multiples of what the normal hourly rate is. And I can tell you that if we get close to 90% of what our actual hourly rates are, we're doing good. And a lot of times you find judges that are just cutting things in half or worse because they're just not used to the understanding that you have a case that may be what's considered a low value case, but you're out there trying to level the playing field for all businesses. I'm a small business person myself. I'm a property owner. I want to bring that common sense to these types of situations. But one of them is using those consumer protection laws to protect other businesses who are out there doing what they should be doing instead of cheating our consumers in our community. So that's one of the specialty courts that I'd like to see develop if we get the funding.
Well,
Magic question.
Yeah.
John.
I agree with what they both said, so I don't want to reiterate all of it and take too much more of your time, but just to add on a little bit, I do think that we need to make sure that we take advantage of the resources that we do have. And with regard to things like Veterans Court, from a judicial standpoint, the judges need to really look at the litigants and defendants that appear before them and make sure that anyone that would benefit from those resources is actually given an opportunity to enter into those programs. I know family court is kind of a specialty court on its own, but there's also nothing wrong with exploring the possibility of more diversion programs with regard to at-risk youth to try and reduce the number of people that are coming up through the criminal justice system later on. So if we can help them at an early age and not have to deal with them later on, that would also be beneficial.
And I've really asked every question to all the judges. I don't want to take over 100%.
You're the best
The,
for
the,
it.
the,
But-
the RJs?
I do. Okay. Well, we'll go with the RJ then.
I didn't get to say it last time.
All right. We'll start with Sean and go down the line. It's no fun asking the same question that they've ever heard me ask. They've had time to think about it. And I think you've heard me ask this question about 6 times, so we expect very good answers from you.
Yes, go ahead.
The RJ has its mythical, but not mythical, its biennial poll, which is supposed to judge the judges, and essentially its goal is to educate, for lack of a better term, civilians on how judges are doing in and of themselves and in relation to their fellow members of the judiciary. What ideas do you have, and again, we'll start with Sean and go down the line, what ideas do you have, Sean, to make it a more accurate gauge of being able to rate the judges when, let's be honest, the vast majority of the public will never actually encounter this judge for any particular reason whatsoever?
So, and I just want to make sure I understand, you're asking for ideas to improve the RJ's poll or some other resource?
Either.
Okay.
I mean, there are problems. No one thinks the poll is perfect.
No, and I think that the poll is beneficial because it is one resource, and it is something at least where people in the legal community that have experience with these judges can provide an anonymous answer and express their opinions. And you would hope that collectively, from a number of people, that there's at least some truth to them. Obviously, one person that's got an axe to grind isn't going to swing the RJ poll drastically one way or another, unless they have the influence over enough other attorneys to convince them to fill it out the same way. So that's one method, I guess. Another thing, I guess I hadn't really thought about what other resources would be beneficial, but maybe some type of reporting service on judges with regard to, the peremptory challenges. That's in the RJ, but it's not really explored. So if there was some group that was interested in providing a resource to the public, you could have some information as to why people were challenged, what the results were with regard to Supreme Court cases when they're overturned, just a small snippet as to this is what they did and this is why it was overturned, so that there's at least a resource out there for the people that are interested in going and checking it out, that it's easy to find. Because as it stands now, most of the time when people look for information about the judges, you get the judge or the candidate's website, which is written by them, telling you why they're great. So if you could have some other group that was actually interested enough in collecting data and providing it as a resource, that would be beneficial.
Okay. Right.
I think one of the things that the RJ could do, they're not about to, is keep the full stories up for a lot longer than the 2 or 3 weeks that they are that they're up there. I remember, I think it was beginning of January that the last Review Journal survey was out there, and by February, March, all you got was a picture of the judge and some of the results, basically the retention rate and a few other, and a few other things. But the story about them, because where they're interviewing the judges, they're interviewing possibly some attorneys that are willing to come forth and talk about that department or that judge, and so forth, are gone. Now I understand you have to protect your copyright, and they're pretty famous for doing so. But in an election year like this, I think that all those stories should be up for the last 6 years, for at least the last 3 running, because that would allow anyone that wanted to have that kind of information to be able to get it without having to start paying, and I don't even know how much it would cost to pay per article, and who knows, and you would have to pay a lot because you have to guess which day of the week that article and that judge came out, because there's nothing on the free website that tells you that. So as an intellectual property litigator, that's one of the things that I kind of look at and wish that there was a better way of doing it. The other things, though, that Sean said, absolutely. I think there should be for any sitting judge a scorecard for reversals, and for things that are brought up, because you can have a judge that has a lot of pro se prisoners that are bringing appeals for habeas corpus all the time because the judge didn't agree that the meal they had wasn't against their constitution or civil rights. So there's reasons why cases go up on appeal that have nothing to do with the competence of the judge, and therefore just that number itself can be as misleading as numbers on the race. I think the other thing is that they the Review Journal, if they are unwilling to put forth and allow complete access during election years to the last 3 surveys, at the very minimum they should have it easy to be able to see how judges are doing during their last full term or partial term. And even that's not easily done. So those are some of the things that I think would make it easier. The bottom line is that people are going to get a ballot that's a half an inch thick. When they get into the polls, they're rolling the tape, and then all of a sudden they're going to get to the judgeships, and their eyes are going to get glassy. I mean, they're not going to see know who 3/4, if not more, of the names are on that ballot, and you're going to lose voters who are not going to vote at all, or you're going to get voters who, as a friend of mine said, they voted for one person because their name sounded like pizza and he likes pizza. I mean, these are not good reasons to vote for judges, but that's what out there. The Review Journal could do, last thing, the Review Journal in itself could do a lot better job of getting out ahead of that and doing a whole series of articles completely nonpartisan about why judges are important. Because the bottom line is, I know what you say, that most people won't see a judge, but of every elected official out there, they're going to see a judge probably more often than they're going to go up to Carson City and see one of their assemblymen or councilmen or governor or whatever, or go to Washington, D.C. to see their congressmen or senators. So when it comes to who the people are voting for, judges are important to this community. They make more of an impact on this community than almost any other individual that is being voted for. And that's something that the Review Journal, the Las Vegas Tribune, and every other organization out there should be getting across to people, is why these positions are important.
The one thing I'd like to see the RJ poll is that the retain or don't retain is just a single button, yes or no, at the end, that bears no relationship whatsoever to the criteria that's been rated. And I think all they should do is take the criteria that's been rated, because from my experience, I think that the folks who actually take the survey try their best when they're rating that criteria to be candid. And there's 3, sort of like, I don't agree, I agree, I really agree kind of categories. And I think if you just bring those numbers down and put those percentages together, that should be the retention rate, because 2 to 3, maybe 100, 200, 300 attorneys per judge are rating them, and if you get 10 folks that go in there with an agenda, either because they're favorable and have been solicited perhaps by someone to rate them highly, or somebody who's got an extra grind and who gets their buddies to go against, it can swing those numbers. So I don't know why the retention number is just a yes or no, independent of the criteria. And the criteria doesn't get a lot of play unless you take the time of going to the full survey. So I think that's how they should determine what the retention rating is. It's just from that criteria of specific voting on those 10, 12 categories, and compile that and decide if that's the retention. Otherwise, I think what Kathy England, when she was president of the state bar, put together when the question 1 was on the ballot about appointing versus electing judges, they came up with, and I think it was based on what Washington State has, very objective criteria that was going to determine and be published about the judges, and it was going to be things like what their appeal rate is, affirms versus reversals. They actually were going to poll jurors, they were going to poll attorneys, litigants, and actually try to have as much objective data as they could about the judges, and that was going to be a component of the retention component of the appointment process, and it was fantastic, and it's just unfortunate that it didn't get voted through.
So basically they just want to sell paper. not invest enough money in to get proper polling.
Well, it seems to me, and I'm just going to follow up on that point, that when they do the articles, and what they usually do is they'll pull 4, 5, 6 articles, it's never the positive side or the good side for the most part. They give a little bit of mention, oh, this got high rating or that got high rating. It's always about who got less than 50%, what the salacious comments were about those people. So I think that lends itself to what you said, which is it's more about trying to sell
Because I
papers.
think on the other side of the aisle, where that individual that wasn't represented by any attorney at all, they may have a lot to say, but wasn't surveyed at all,
And they're not being polled at all, exactly.
and which that should be.
Yeah, I think that you can blame some of that, the idea about a retention rate as the bottom line be-all and end-all on Siskel and Ebert, not the movies, because people just, whole generations got used to the thumbs up, thumbs down after the very detailed analysis of what went on. And I think that you have lots of organizations that still fall back on that.